You've just purchased a home and your sale is conditional on financing. As it turns out, your dream property just hit the market and you're no longer interested in the property that you've agreed to purchase already. Can you simply go back to the seller or their salesperson and say that you didn't get financing and move on from the transaction? Well, from a legal perspective, you should appreciate that there are consequences of such an action. Every agreement of purchase and sale, whether it's written in the actual agreement or not, has a good faith provision implied into it. This means that the parties will make reasonable efforts to discharge their contractual obligations. If you're a buyer and your offer is conditional on financing, that means you're going to make a reasonable effort to go to the bank and obtain satisfactory financing. Now, if you're simply using this as a loophole to walk away from the transaction, this is lack of good faith. Now, if I was the seller or the broker on the other side, and I could put together the fact that you did end up purchasing a home, equivalent value or similar value, you did end up qualifying for financing, I would put together the evidence and sue you for lack of good faith. So you should appreciate that even if it's not in the agreement, these sorts of conditions, inspection, financing, whatever the case may be, they're not meant to be legal lacunas or loopholes that you can use to kind of avail yourself to better properties. You have to legally do what you're supposed to do under the agreement and make reasonable efforts to complete the same. I hope this video helps, and we'll see you next time.